Hi, my name is Shawn Good, and I'm a Social Security disability attorney with the Good Law Group in Palatine. In this video, I'm going to talk to you about hearings. So hearings in a Social Security case are conducted at what they call ODAR, the Office of Disability Adjudication and Review, or what's now called, I think, OHO, Office of Hearing Operations. So they're throughout the country. There's probably hundreds, if not thousands of them. They're not like typical court proceedings. This isn't a courtroom per se. It's more of a conference room. It's a little bit more laid back. It's informal. Most clients do not dress up and try to put on a show like they can go to work at these. Typically, to get to a hearing, you're going to be denied twice. You'll be denied at application first, and then at reconsideration, and then third, you will ask for a hearing. And that's what we're going to talk about. So this is not like a divorce courtroom or a traffic courtroom. You're not going to be sitting behind a witness stand. The most formal part about this whole thing is you'll raise the right hand and promise to tell the truth. Typically, the judge will introduce himself. He'll talk to your attorney about the evidence in the record and whether it's complete. Your attorney may give an opening statement. He may give a closing statement. He may give neither, or she, excuse me. The attorney, it really depends on the judge, what the attorney wants to do, and sort of the relationship the attorney has with the judge, whether it's opening statements or closing statements. I do them sporadically. They are really designed to give the judge information, not to be super persuasive. This isn't a criminal case where you're trying to sway a jury. So keep that in mind. If your attorney doesn't do it, don't get mad at him or her. It's pretty reasonable. So there's other people in the room besides you, your attorney and the judge. Typically there's a vocational expert. This person's going to testify to your past work and any other work that's available in the national economy. In about 10 to 20% of the cases, and it varies depending on the judge, there will be a medical expert in the room or available by phone to give testimony about your impairments and whether they meet or equal listing, and basically whether you can do any work despite what's in the record. Also, there will be a hearing monitor in the room, and this person will be doing the audio recording. You can think of them as a court reporter. This is audio. They are audio recorded, so it's important to say yes, no, and answer fully. Nods, shakes of the head, they don't work. Judges get pretty annoyed with that. I always try to remind my clients, and really everybody should know this, when you go to a disability hearing, it's really important to remember why you're there. You're there because you can't work. You're not there because nobody will hire you, or you can't drive, or you live too far in a remote area and there's no public transportation. All those things are irrelevant. This is a disability hearing. You're there because you can't work. There's some variability based on your age and work experience, but overall, they are for people that cannot work. So, there are appeals after the hearing. I know it's been, for most people, if they do get denied, 2 to 2.5 years, but the case is not over. There's still the Appeals Council and the Federal District Court and the Court of Appeals, and in some very, very, very rare cases, the United States Supreme Court. So, although you don't want to go to those things, don't give up if you still feel like you're unable to work after a hearing and you get denied. So that's just a little bit about hearings. If you want a complimentary case evaluation, give my office a call, 847-558-1894. Please like and subscribe to this video, and you can find us on the web at thegoodlawgroup.com. Thanks for watching.